Internet Caucus Committee held a briefing last week on the Obama administration's announcement that it would no longer maintain control over technical functions of the Internet. A panel of Internet policy and governance officials discussed what relinquishing control could mean for the future of the Internet, with nations like China and Russia publicly advocating taking control of the Internet from the U.S. The panel also talked about how this could impact U.S. companies and online freedom.
Great. Thank you. Thank you, Tim, and thank you to the Congressional Internet Caucus for hosting this event. As Tim said, before I introduce our panelists, as Tim said, the topic of the conversation today is the Electronic Communications Privacy Act. I just wanted to provide a little bit of context for the discussion before we get started. The Electronic Communications Privacy Act, or ECPA, was passed in 1986. Congress passed ECPA in order to provide privacy protection for electronic communications. Congress discovered in the 80s that technology had outpaced the privacy protection it had provided for voice communications when it passed the Wiretap Act in 1968. So in 1986, Congress passed ECPA to extend those same protections to cover new forms of communication, in this case digital communications, electronic communications. Now here we are again, almost 30 years later, and changes in technology since 1986 have prompted Congress to take another look at ECPA to see whether and how it should be modernized to protect the privacy of communications and content that is sent and stored online in ways that were not possible 30 years ago. And as you probably know, several bills have been introduced in Congress to reform ECPA to do just that. So looking forward to our discussion today. I'll introduce our three panelists, and I'll just, after I introduce them, I'll explain what each one will start off discussing, and then we'll get into a more free-flowing discussion. But to my left is Richard Downing, who's the Principal Deputy Chief of the Computer Crime and Intellectual Property Section at the Justice Department. It's also called CSIPS. CSIPS is the office that investigates and prosecutes computer crimes and advises the department on issues related to law enforcement's collection of electronic communications and the use of emerging technologies in criminal investigations. To Richard's left is Jim Dempsey, who's the Vice President of Public Policy at the Center for Democracy and Technology, where he focuses on Internet privacy, government surveillance, and national security issues. Jim is also a former counsel to the House Judiciary Subcommittee on Civil and Constitutional Rights, so he has spent time up here as well. To Jim's left is Katie McAuliffe, who's the Federal Affairs Manager at Americans for Tax Reform, and she's also the Executive Director of Digital Liberty, where she focuses on telecom and technology issues, including ECPA reform. So I thought we'd start the discussion today with Richard, who is a terrific person to explain how law enforcement uses ECPA to obtain information necessary to investigate and prosecute crimes. We'll then move to Jim, who can talk about how ECPA was designed for communications technology as it existed in 1986, how that technology has changed since then, and why many argue that those changes have eroded the privacy protections that ECPA currently provides. And I'll look to Katie to talk about some of the different approaches to reform that we see in some of the bills that have been introduced. So with that, Richard.
Great. Well, I want to thank for the invitation to come and speak with you today. I'm very interested to engage on this issue and very interested in your questions later. What I'd like to do to begin with is to give you a bit of a thought experiment. What I'm going to do right now is deputize all of you. You are now assistant sheriffs in a small town, and you are sitting at the intake desk, and in walks a woman who says that her daughter has given her an email that she received that states basically that some kids that she doesn't know are going to be coming to her school in a shooting rampage sometime soon. So your job now as the intake officers decide how you're going to deal with this very serious situation. And the answer, it turns out, is that you're going to need to get a bunch of information from providers to be able to figure out what's going on here. One thing you would probably want to do is to say, well, this email was sent from a particular email account. Who was the person logged into that email account at the time that this message was sent? What was the internet protocol address, the IP address of the person's computer, as a way of figuring out who that individual is? You might also want to know, well, what other email accounts has that person been communicating with? Who else might be involved in this shooting? Who else might be supplying information or perhaps a gun for this individual? Another thing you might be interested in is, what is the content of other emails in that account? How do we know this is a real thing and not a false threat? Can we figure out who is involved by looking at the text? Can we figure out what it is they're going to be doing? This is a core way that ECPA is involved in criminal investigations, because it is the statute that controls the way that law enforcement officers obtain information from a provider in that kind of situation. And if you think for a moment, it's hard to think of a crime nowadays where this sort of evidence is not going to be relevant and important. So your next week on the job, you get a report of a gang shooting, and you're now very interested in knowing who might have been in the area around it. What text messages is a potential suspect sending? What was the content of those messages? Can you use any of this information to figure out who is involved? The next week on the job, you're an undercover officer, and you download an image of child sexual exploitation that has been uploaded by the person who is molesting the child next door. How are you going to figure out where that image came from? How are you going to figure out who that person is? How are you going to figure out who else that person's communicating with, and so on? The next week on the job, you receive a report that a major retailer has been hacked, and they've been stolen from them has been 40 million credit card numbers. What are you going to do? How do you figure out where that hack came from? How are you going to figure out where the money went? And even you get a report of a missing child. Is it a runaway? Is it a kidnapping? Where's that child's phone right now? They had a phone on them when they went missing. The provider may have information to be able to locate where that phone is, and perhaps to be able to save that child. So these examples, what I want to impress upon you is really the breadth and importance of ECPA for law enforcement investigations. The statute controls the way that law enforcement officers are able to obtain electronic evidence stored at the provider. So we're not talking about searching people's homes. We're talking about information stored by Google or Verizon or Facebook. And we're also talking about the broad scope of what's involved here. Sometimes what's involved is the content of a communication, the body of an email, for example. Sometimes what's involved is non-content information. It could be the to and froms on the email account, or the IP address of the person who was logged in, or even perhaps the cell tower nearby where that person is, because his phone was being used to communicate through that tower. To be clear, we're also talking about criminal investigations, of course, also civil investigatory matters that the government might be involved with. Because when the SEC or when the Department of Justice is investigating, let's say, an environmental matter or a civil rights violation or various civil fraud matters, this is the statute that controls access from those investigations as well. What we're not talking about, just to be clear too, is whatever the NSA is doing, anything to do with the Foreign Intelligence Surveillance Court. Those authorities are different than ECPA, and so I just want to make sure that we're focused on the right set of issues here. This doesn't have anything to do with NSA's alleged bulk collection that's been going on. So you're the officer. How do you obtain that information? What's the standards, and how does this work? Well, let me give you a couple of examples. If what the investigation needs is the name and address on the account, so perhaps you've got the IP address, the Internet Protocol address of the computer that sent the email with the school threat. And you need to find out where does that person live, who's the name and address on the account. Then that is required to be used, ECPA requires that you use a subpoena to do that. And here, by subpoena, to be clear, various types of subpoenas, but you could imagine a prosecutor issuing a subpoena on behalf of a grand jury in order to require the disclosure of that information from the provider. Slightly more sensitive information might be the to and froms on the account. So now it's not just the person's home address, but you want to know who the person's been sending and receiving email from, perhaps to identify other people who are involved. ECPA requires the use of a court order. So there the officer would go to the local prosecutor, present information to the prosecutor and convince him that it's necessary. The prosecutor would then prepare an application, go to the court, and present that evidence to the court to justify the court to issue the subpoena, the court order. I don't know what that is.
Yeah, why don't you...
Is that any better? So the prosecutor would then take this information, prepare an application, go to the court, and the judge would evaluate whether the standard has been met, which is a medium-level standard, and then, if the standard has been met, issue the order to the provider. And finally, in most circumstances, if we are obtaining the content of those emails, the statute requires that we obtain a search warrant, similar to the kind of warrant that would be used to obtain access to someone's home or business. Again, there's an affidavit, and neutral magistrate reviews that and evaluates it before issuing it. What I want to just mention briefly here too is that you'll notice that there's a wide range of different kinds of process, and so I caution you when you hear the people refer to process as warrantless, it conjures up the idea that the officer can just walk in and do anything he wants because of warrantless, no warrants required. Actually, there's a fairly careful and graduated set of rules that are all laid out in the statute that require certain types of process other than a warrant in certain circumstances. I would also mention just briefly that speaking on behalf of the department, we are very concerned that we follow the rules, that we carefully weigh the situation with regard to privacy and the privacy invasions that are incurred as a normal course of criminal investigations. And so we are very interested in making sure that the balance is correct, and very interested in making sure that this statute works properly for the purposes that it is put, which is, as you can see, very critical to public safety. Very important in so many different kinds of criminal investigations that we use to help protect the public from violent and other criminals in the course of the work of the department and of law enforcement. So I'm now de-deputizing you. You can go back to your regular jobs, and I would pass it on to Jim for the next part of our talk.
Thanks, Richard, and thanks to the Congressional Internet Caucus for putting this on. Libin, thanks for moderating. I wanted to start by re-emphasizing a point that Richard made, which is that the Electronic Communications Privacy Act is separate and distinct from the national security and foreign intelligence authorities of the government. So there's been a lot of debate, obviously, in the past 9 months or so about NSA, about bulk telephony collection, about various programs that are conducted under the Foreign Intelligence Surveillance Act. We have two parallel sets of rules. We have a comprehensive set of rules for collection of electronic communications in the foreign intelligence and national security arena, and then a comprehensive set of rules that are different in some ways in the criminal law enforcement and civil arena. And so we're focusing, as Richard said, on that criminal justice and civil enforcement and civil litigation context here. And that's what ECPA, the Electronic Communications Privacy Act, regulates. Ironically, in the way that we're going to be talking about today, the standards under ECPA are actually weaker than those under FISA. The President has said and has emphasized correctly that in order for the NSA to get access to the email of a person inside the United States, the NSA needs to get a warrant from a judge. For domestic collection, for collection about anybody inside the United States, the NSA needs to get a warrant. Under ECPA, and this is the problem that we are pointing out, ECPA as it is now written says that government agencies do not need a warrant in the ordinary criminal cases of the kind that Richard has talked about and in other non-national security cases. So if anything, people often think that the national security standards are more favorable to the government because of the unique interests at stake on the national security side. In fact, here, the privacy protection standards are weaker in the ordinary run-of-the-mill criminal investigations. Now, it's hard for many of you to appreciate, I think, how far we've come in technology since 1986, when the Electronic Communications Privacy Act was first enacted. In 1986, it was what, I don't even know if people now know the term, it was a dial-up world. You used to dial in through a telephone line to your internet service provider and download your email onto your laptop, at which point that email would be deleted from the server of CompuServe or AOL or any of the other email and internet service providers. Now, of course, fast forward to 2014, and we're in a world that's characterized by always-on technology, ubiquitous, broadband, wireless, and the emergence of what we call the cloud, which is the remote storage of information, not on your personal device, not on your laptop, not on your desktop, but with the third-party service provider where it's available all the time, backed up, secure, and available from any number of devices. A remarkable, remarkable development, which Congress did not anticipate in 1986. Even the people building the technology didn't anticipate it in 1986. All the emphasis was on pushing power to the laptop and creating more storage capacity locally. So the question is, how do we facilitate law enforcement investigations and access to all the kinds of information that Richard talked about, which is critical to a whole range of criminal investigations, including very, very serious matters, including matters where time is of the essence. How do we facilitate law enforcement access to that information while implementing and enforcing our traditional rights? The Constitution, of course, in the Fourth Amendment, protects the right of the people against unreasonable searches and seizures in their persons, houses, papers, and effects. And I think it's pretty clear that everybody would accept now that digital material is covered by papers in the Constitution. But the problem that has plagued policymakers, the courts, Congress, really for over 100 years has, what about data that leaves your possession, data that is delivered to a third party for processing or delivery? And we've seen really for more than 100 years an interplay between the courts and the Congress in trying to establish rules for how do you protect that data. Back in the 1870s, back in the 1870s, the Supreme Court ruled that letters, when they leave your possession, when you hand them over to the Postal Service, a government agency, are protected by the Fourth Amendment, and the government needs a warrant to open postal mail. In the 1960s, the Supreme Court ruled that the voice of your telephone call as it passes over the wires and through the network of the telephone company is protected, and that the government needs a warrant issued by a judge in order to intercept that communication, a warrant issued based on a finding of probable cause to believe that a crime is being committed, which is the constitutional standard. In 1986, as Nancy said in her introduction, it was unclear, well, what about wireless communications? And what about non-voice communications, data communications? And Congress adopted ECPA. The courts were moving slowly on this issue. Congress said, we have this new technology. We need to create a trust platform for these technologies to succeed. And Congress adopted ECPA in 1986 and said, voice over the wireless network is protected and requires a warrant for the government to intercept, except in emergency cases, which are recognized, of course, under the Fourth Amendment. And data, non-voice communication, Congress said, is protected as it moves through the network of the then just emerging Internet. What Congress didn't really anticipate, as I said, was what about data at rest? What about communications when they are stored, not locally, where we would all agree they are protected, but remotely? And that's where Congress just dropped the ball, didn't anticipate where the technology was going, and came up with a very complicated set of rules, the bottom line of which, though, is a lot of data content, just like the letter, the email, just like the telephone call, the voice, the text, the documents, stored with a third party. Congress said in ECPA, they should not be protected by the warrant requirement. They should be available to the government with a subpoena issued by a prosecutor or, in some cases, by FBI or DEA in certain cases, with no judicial approval and no finding of probable cause. And obviously, technology has moved way beyond that, and we believe it is time to update ECPA to say that a warrant is necessary for the government to compel a third-party service provider to disclose that content, again, except in emergency cases, except with the consent of the customer and the other exceptions that you would normally have to the Fourth Amendment. In 2010, my organization, the Center for Democracy and Technology, put together a coalition of companies, trade associations, and public interest groups called Digital Due Process. We launched with 30 members. We now have over 100 members. I have a sheet outside that lists all of the current members and lists the principles for ECPA reform based on the proposition that the government should have access to data using a variety of instruments, including the subpoena for the less for the non-content data, but that to get the content, whether it's a telephone call, whether it's a letter in the Postal Service, whether it's an email in transit, whether it's a text in storage, whether it's a document stored with any of the online services, the government should meet that constitutional standard. One Federal Circuit Court of Appeals has ruled that ECPA is unconstitutional precisely because it does not require a warrant for access to stored content. Our proposal would cure that constitutional defect, put ECPA back on a sound constitutional basis. The pending bill in the House is H.R. 1852, introduced by Representative Kevin Yoder and Representative Jared Polis, now has 200 co-sponsors. I'm going to turn it over to Katie McAuliffe of Americans for Tax Reform, one of the charter members of our Digital Due Process Coalition, to talk a little bit more about the pending legislation, and then I think we'll probably come back for a second round to some of the issues at stake here, and we can also talk a little bit later about things other than content. For example, cell phone tracking data, which is also covered somehow by ECPA, although Congress in 1986 didn't again anticipate cell phone tracking, didn't really fully anticipate where the wireless industry was going, never anticipated how ubiquitous it would be. And ECPA covers tracking data but does not require a warrant for it. And again, we think that's another one where there should be a warrant. But let me yield to Katie McAuliffe of ATR.
All right, yes, Katie McAuliffe with Americans for Tax Reform, Digital Liberty. I want to thank Richard and Jim for that great background there on electronic communications privacy forum, kind of where we are and where we're going. I'm probably going to reiterate a few things that they've said, maybe in different words, just because I've heard it takes hearing something 7 times to actually remember it. So I think I've heard that 7 times. So when talking about this, there are a bunch of different aspects to ECPA. There is warrant for content, there's location tracking via cell phones, there's pen, trap, and trace. I'm leaving one out. Leaving it out. So we've got these 4 different principles, but the one that we want to focus on right now is warrant for content. So as Jim was describing, content that is held in your email and a third-party service provider, content that's held in the cloud, content that's held by Facebook, content that is in your Google Docs, those kinds of content. And one of the things that's really interesting is that, like, on my phone here, depending on what button I hit and where my information is saved, actually determines how that information is protected. So if I save a photo to my phone storage, then it has warrant protection. But if I save a photo to my iCloud, it does not have warrant protection. So that's a strange difference right there. And I think that's something to really think about, the inconsistency there, and to think about papers that are in your file cabinet at home have warrant protection, but papers that you save in Google Docs do not. So that's one thing to really think about when you're talking about electronic communications privacy reform. As mentioned, there are a bunch of different things that go into this topic, and Richard touched on a few of those, and so did Jim. So I want to start out with talking about some of the bills that are around. Congressman Chaffetz has a bill that is fully focused on location tracking. It is a great bill, comprehensive, few things to work on, but it's definitely something to keep an eye on moving forward. From my perspective right now, it's a very complicated issue to kind of try to get everything pulled together. Content is the first step in getting an education on how this kind of information affects our lives and affects our privacy. So that's a great bill to be watching. One that Jim mentioned was the Yoder-Polis bill in the House that has over 200 co-sponsors. If you are not on that bill, you should take a look at it because it's got some great information. If you have any questions, I'm happy to tell you about it. But their bill mostly covers warrant for content, and it mirrors the bill that's in the Senate sponsored by Senators Leahy and Senator Lee. So these are very similar, and basically what it lays out is that your email, stuff stored in a third party, shouldn't be treated differently than stuff stored in a file cabinet at your house, that a warrant should go to the service provider as well. And you can subpoena me. You can subpoena me to get my stuff. But you need a warrant to go to the third party. So that would clear that up and let me, as a user, have control over my data to decide what has privilege and what doesn't. And privilege meaning, like, I'm not trying to share my doctor's notes or my love letters in an investigation, but anything relevant to the case, like say I did something fraudulent or something was wrong with my lobbying and someone's coming after me. That's the kind of stuff that would have to be turned over. And, you know, being able to decide that privilege is very important. There's another bill that kind of combines both of these, the location aspect and the warrant for content, and that's sponsored by Representatives Lofgren and Poe, which is a good comprehensive overlook. But really what I want to focus on and what I think has the most steam and really shows that Americans, or shows what Americans want to see from Congress, they want to see from the administration, is that they care about privacy. Because again, this is separate from NSA. This is not about foreign intelligence. This is about domestic investigations. And those domestic investigations are very important, and it's important that they work well, and it's important that companies are able to comply in a way that is consistent. And by having a warrant, they don't have to worry that they might be breaking a contract with their users, and they make sure that they're getting the police or the agency who's investigating everything that they need. And so that's all a very clear process. Some of the examples that Richard gave, things like child pornography or someone with an email that's talking about a plan, you know, those kinds of things are, there are emergency exceptions for that kind of content. So those things can be gotten to, and maybe a warrant gone back to you afterwards, Jim, or?
Not really, no.
No. Okay. So the warrant, not necessarily getting a warrant afterwards, but there's an emergency exception for those types of cases. In the instance of gang violence, that would be a criminal investigation, so you would need a warrant moving forward on that. And hacked retailers, there are actually a lot of voluntary agreements out there for sharing information, and I'm quite sure that Target was more than willing to share information to solve their problem. And that's why a lot of retailers have actually joined in groups that are data sharing on possible threats to their security, which is something that they haven't done in the past, and they're moving forward in that direction. And that can help curb a lot of these data breaches as well. So one of the things that also comes up, so we've talked about criminal, right? So these are criminal investigations. Criminal investigations, you need a warrant, you need a warrant, you need a warrant. And one of the ways that you build a case for criminal investigation is to know who sent what to whom at what time. And you can get that with a subpoena. You don't have to come to me. You can get that with a subpoena from the third-party service provider to build your case to get a warrant on the criminal side. On the civil side, as Jim was talking about the case in the Ninth Circuit, they were in civil investigations, which have a lower burden of proof. They were using a subpoena to get similar information that you might have to use a warrant for in a criminal investigation. So that is, it's kind of a break if you think about it, the more serious crimes and the less serious, as we've determined between criminal and civil. That's why they're separated out that way. So one of the things that's come up is civil investigative agencies have said, if, you know, hey, you make these updates to ECPA as noted in Leahy-Lee or Yoder-Polis, then civil regulatory agencies like the SEC, Consumer Financial Protection Bureau, EPA, FCC, FTC, OSHA, everybody has the ability to, they wouldn't have that ability anymore. So they've kind of asked for some kind of change or an amendment to give them some kind of warrant authority, which is very interesting because they have a lower standard of proof, but they would have the power of a warrant, and they'd be able to do these investigations if an amendment like that were added to the already written legislation. But the other thing about civil agencies is that they share with criminal agencies. So a criminal agency would have had to get a warrant to do this particular work, but the civil investigative agency doesn't have to. And they share that information. So in that way, you're circumventing the legal structure that's put in place to protect our Fourth Amendment rights. So it's very important that Yoder-Polis, that Leahy-Lee pass as they are without amendment from my perspective at Americans for Tax Reform, because that ensures protections to Fourth Amendment rights, and it also still ensures that law enforcement can do their job. Because in the civil investigations, they can issue preservation orders to third-party service providers, and they can subpoena me, because the question is like, well, what if Katie dumps all of her emails that we need for this investigation? Well, it doesn't matter because you put a preservation order with the third-party service provider. They can compare what I've given them to the metadata, the to and from timestamps, with the service provider and say, you know, hey, we know that you've been talking to this person. This is a colleague or someone who, you know, we know you have a criminal or civil violation type relationship with, and we want to see this email. The thing is, that's so much work. It's so much work to go through all the paper. And it's so hard, and it's so tedious, and the Fourth Amendment is such a bummer. But the Fourth Amendment is really important, so it needs to be protected. And I'll stop there.
Thank you. I think I want to pick up on what Katie was just talking and also give Richard a chance to talk a little bit about the issue of a civil investigation and what it would mean to give, to require a warrant for content, what that would mean for civil agencies conducting investigations. And first, if either Jim or Katie could talk a bit about possible workarounds. I understand that that could be a sticking point to legislation that requires a warrant. What are some of, you mentioned a preservation order, but what are some of the other possible workarounds for the SEC and other agencies?
Well, the SEC and other regulatory agencies have subpoena power, and traditionally they have served their subpoenas on the targets of their investigations or on other people who may be the senders or receivers of letters or email or documents that may be relevant to an investigation. And the process has always been that the regulatory agency serves those subpoenas. The recipients of the subpoenas, the people who created the record, the account holder, the sender or recipient of the letter or of the email, goes through all of their files in their possession or control, meaning everything they have locally and anything they have remotely stored. You pull it all together, you cull through it, you determine what's relevant, you make a production to the government. If the government feels that you haven't fully produced, if the government feels you're withholding stuff, the government makes a motion to compel, conducts further inquiry into what kinds of records you might have. They go to additional witnesses or parties in the case, in the investigation, and through that adversarial process, through that motion to compel process, the production is defined, the scope of the production is defined, and the person is compelled to disclose their own data.